So good afternoon, everybody. First of all, welcome to this panel. Now we are going to host two sessions dealing specifically with surveillance. The first one will focus on surveillance and criminal law, whereas the other one, the following session, will be on surveillance, democracy, and the state. I'm particularly happy to be the chair of this panel on surveillance and criminal law. It's co-organized by CPDP and a FP7 project called IRIS, Increasing Resilience in Surveillance Society. First of all, of course, I introduce myself. My name is Antonella Galetta. I'm from the VUB, the Free University of Brussels. And as VUB, we are also part of the project IRIS, Increasing Resilience Against Surveillance Societies. Well, first of all, I would like to talk to you briefly about the idea behind this panel. Why did we decide to host a panel as CPDP on surveillance and criminal law? Well, there are several reasons behind this, but I would like to highlight two of them in particular. The concept of surveillance has been widely developed in philosophy and social sciences. However, a systematic legal analysis of the impacts of surveillance on human rights is lacking from a legal perspective. And this is particularly the case of the presumption of innocence, for example. So this is why a panel on surveillance and criminal law was one of the main issues we wanted to focus on. And secondly, it is also true that for us it is apparent that surveillance has an impact, or at least affects an impact on privacy and data protection. However, it is also important to say that in general, privacy and data protection are not the only human rights that are affected by surveillance and the deployment of surveillance systems in our daily lives. So, before going into the details of the panel, I would like to briefly present to you our speakers. The panel will be moderated by Marx, Professor Emeritus at the Massachusetts Institute of Technology. 4 different presentations will follow. First of all, Ulrich Seldeslachts will give a presentation on the surveillance industry in Europe. Ulrich is a Chief Executive Officer at LSEC, an industry association of information security experts. Then Rachel Robinson will give a presentation. She's a policy officer at Liberty, the UK National Council for Civil Liberties. Then we have the pleasure to have among us John Vervaele. He's professor, among other things I would say, professor in economic and European criminal law at the University of Utrecht. And finally, we'll have a presentation from Didier Wallaert. He's a lawyer, a senior associate at DLA Piper. So I'll now give the floor to Ulrich, and thank you for your attention.
The watchman next to me. Thank you very much, Antonella, for the invitation and also for the introduction. Very well done. I'm sitting here, maybe not always from the right perspective, because I'm actually trying to convey to you that we need to have some form of surveillance in order to be protected against some criminal activities. And that's not probably the best way to start in a privacy conference as we are having here. But in any case, there has to be somebody the bad duck, and so that will be me. I'll try to talk to you about the purpose of monitoring. Why do we do these things, and why it is absolutely necessary and definitely also very useful. So basically, first a short introduction about us. Why are we here? LSEC is an industry association. We are existing for now for over 10 years. We bring together different players in the IT security space mainly, where we are trying to focus them on bringing technologies into the market and also trying to help enterprise and government understand why these technologies exist and also why there needs to be done something on security, namely information security. With all of these companies, more than 120 members we have by now, we reach out to over 3,500 IT security professionals and about 25,000 enterprises in Europe. We organize different industrial projects, which are partially research projects, and I'll talk about those in a very brief second. And we organize mainly different types of activities, like we are also supporting CPDP and organizing different other types of dissemination types of activities on information security. So we are based upon, let's say, the expertise of many other companies, and I'm personally more a generalist and try to understand both the concepts of why do we need security, how does security need to be managed, and also more and more into the world of privacy and where privacy meets security and reversely. So firstly, information security is also about monitoring and electronic surveillance. What we try to do in security and information security is try to protect assets, and typically they are digital assets, and sometimes those digital assets, as you know, are representations of the physical world. For instance, your electronic identities or your digital identities overall. And so basically, some of the aspects that we try to do is protect those assets, and specifically the data, of course, about this. So we can't just talk about those things aside from not forgetting what the threat landscape looks like. And probably as you know, and as you probably have been reading the press this morning and over the last couple of days, an increasing number of threats are appearing, have been appearing. Those are coming from the web, cybercrime, alikes. But there's also other types of activities happening these days. So from the industry, these are a couple of things that we see. And how do we see those things? I'll show you in a second. But it's not only from the industry that we see those things. We also partner with the different police forces, like the EC3 that was here yesterday, and here in Belgium, for instance, with the Federal Computer Crime Unit, FCCU, who also sees, of course, quite a lot of criminal activity. For them, they're focusing, for instance, in this case, on why are criminals interested in, specifically in this case, cyberspace. And also some of the activities that criminals tend to deploy over there. So for businesses and enterprises and all of us as individuals, there's quite a number of challenges. How do you gain awareness of the global threat landscape? How do you identify threats if you understand and if you see that there's more than 30,000 new malicious codes happening on a weekly basis? So that's about 6,000 or 7,000 these days a day, new types of threats that are being discovered. And I'm only talking about those that are being discovered, not yet about those which we don't yet are capable of discovering for many different reasons. And so those are quite astonishing figures, and it's quite difficult to grasp all of those and to protect all of the enterprises and citizens throughout the landscape. So for this, companies like Symantec, but it could also have been a slide from McAfee or any of the other large industry vendors, they have international networks available. Actually, the software that you have that's sitting on your machines and that is trying to watch all over the place in trying to understand what's happening in terms of potential malicious attacks. So there's one aspect that you could ask yourself, okay, what if you have those types of software installed on your machine? That means that somebody is actually watching over all of the data that you transmit and that you process, and that's partially correct. And then again, from the police forces, there's the question on how to combat cyber criminals. So if we have an understanding based upon all of the information that we try to collect on where the different threats are, we should also be capable of analyzing how the criminals are actively processing. So we don't only try to understand the threat landscape, but also we try to understand how they operate and therefore also how to mitigate against it. So there's different types of technologies, deep analysis, deep packet inspection, just packet inspection. There's different flows that we try to understand where they come from and where they are going to. So this is a short overview of how such a threat actually could be consisting of. This is also coming from Symantec and a specific case which happened, this was January last year. Based upon a large attack that was happening. And so in about 5 or 6 days, through the analysis and through the different deep inspections with all of the clients, we were capable of understanding where the threats were coming from, and also to update, push those updates out to the end users and protect the machines that were active on it. So quickly further, LSEC is also part of the European Security Innovation Network, which is bringing together IT security and the physical security landscape. And I just bring to you a very short video that hopefully explains a bit on how this actually also applies into the physical landscape. And I'm sure you all know about those types of activities, but just to show you. So Omniperception is a UK company, and they do video analysis and specifically facial recognition. And this is how they do this.
This is the ultimate real-time identification tool. Checkpoint S uses Omniperception cameras specifically designed, tested and proven for facial identification use. As subjects move past the camera, Checkpoint S automatically captures an image, extracts the facial features and compares them against images in a watch list of pre-selected images. The search is completed in a matter of seconds, and if a match is recorded, Checkpoint S relays alarm information in real time. Patented light immune technology allows Checkpoint S...
So I'll skip this just very briefly here, the advertising part. In the next part of the video, what you'll see is this type of activity. So if there is a wanted figure and actually also a photograph of this person, the video system is actually capable of identifying the person based upon this facial recognition. So this video you can easily look up on YouTube. There's many of those examples, many of those types of technologies out there by now. So Omniperception is just one of those companies which is part of the large group of activities. So coming back to this, 2 minutes, 1 minute, no more? 2 minutes, excellent. So security is about identifying potential risk and mitigating the threat, the capability of identifying perpetrators and collecting evidence. So this is what we try in the security sector mainly to do. Just quickly showing you that we have a number of these projects about this, where we actually are researching, bringing research together with industry to help the industry in improving in this. And in this case also, of course, using the expertise from the industry specifically on things like privacy and privacy by design, and helping those companies actually understand how they should implement and use concepts like privacy by design, which is fairly new to them, I must honestly say. So you've heard this morning, if you've went to the plenaries, about the anti-botnet pilot action, so I won't go into detail there, apart from saying that we're also a partner in that. And in this botnet activity, the whole concept is also here, is trying to find ways, technologies that we are going to put into this pilot on how we can test those technologies and improve the capabilities of identifying the potential threats and fighting botnets. So for us, it's also an evolving landscape from the industry where we are trying to understand how we actually can do an impact and make sure that we can reduce the impact of things like botnets happening in the market with the technologies and the resources that we have. So this is more or less a whole reasoning behind this. Just to close down with the last 30 seconds that I have, another project that we're working on has to do with mobile wallets and deploying mobile wallets. Now, how can we do deployments of wallets where we know today that a mobile phone is not secure? One of the concepts that we have, which is being applied, and again, that's something that you should be aware of, if you are using MasterCards or any type of credit card or debit card for that matter, the banks behind this and the financial transaction services behind this are doing analysis on your data and on your transactions and mainly to prevent fraud. So also here we're trying to use the fraud technologies available, anti-fraud technologies available, in order to prevent, again, misbehavior and in order to be able to identify malicious activities happening there. That's about it. Thank you.
Hello everybody, very happy to be invited along to speak to you today. I'm from Liberty. For those of you who don't know about Liberty, we are one of the biggest domestic human rights organisations in the UK. We work on civil liberties issues across the board, but we've been around for 80 years now nearly, and one of the core issues for us has always been protection of personal privacy, and in particular when it comes to law enforcement, where it comes to the criminal justice sphere, this kind of distinction between citizens and suspects and mass surveillance and monitoring and the impact that can have on a population. So that's been an ongoing concern. Interestingly, our position is relatively nuanced. We certainly aren't against databases. We don't have a problem with surveillance when it's targeted, when it's proportionate. However, we have noticed a trend in the UK over the past sort of 15 years or so, a kind of disconnect between sort of intelligence-led policing and law enforcement, and the use of surveillance and monitoring tied very closely to intelligence-led policing and law enforcement, and mass surveillance and monitoring techniques which essentially turn citizens into suspects and are applied in a completely untargeted way. So when we got the coalition government in the UK, we had high hopes for this government, which had made strong commitments. Our Prime Minister there and our Deputy Prime Minister very engaged in the debate around personal privacy whilst in opposition, very conscious of some of the measures introduced by the last government, which had very serious implications for personal privacy. So we saw when they came in some really important developments in terms of measures which have been packaged as law enforcement protection measures, measures justified on the grounds of keeping us safe, of maintaining our security. A number of those introduced in a completely untargeted way, which I'll go on to talk about a little bit later, by the last government, were effectively abolished or made to be more proportionate, more targeted by this government when they first came in. We had the abolition of plans to introduce ID cards in the UK, the introduction through our Protection of Freedoms Act of a more proportionate DNA retention regime. Prior to the Act, we had indefinite retention of innocent people's DNA in the UK. Liberty took a case about that to the European Court of Human Rights, and we won. We also saw in the Protection of Freedoms Act provision for better regulation of CCTV. Still a lot left to do. Still leaves a lot to be desired, but at least some sort of regulation, some sort of guidelines. And again, perhaps not so relevant for here, but another big issue for Liberty, more circumscribed powers when it comes to stop and search without suspicion. However, notwithstanding those positive measures, we have some really serious ongoing challenges when it comes to law enforcement, criminal justice and protection of personal privacy. Our statute, our legislation for the regulation of investigatory powers used by law enforcement agencies and public authorities without a very pronounced law enforcement remit even, it causes us a lot of concerns. We have seen very many cases of local authorities, local councils usually, using sort of James Bond style surveillance techniques to check whether somebody's sending their child to the right school in the right school catchment area. We've seen police really seriously misuse covert human intelligence sources as part of sort of sting operations involving environmental activists. And we've seen, in terms of access to electronic information in terms of communications data and elsewhere, we've seen a very inadequate regime of access, with many types of organisations able to access our personal data for a variety of reasons in a very uncontrolled way, and often with authorisation coming from within the organisation itself. But the thing I wanted to focus on a little bit more as an example of a very unfortunate sort of trend, if you like, in terms of surveillance monitoring and criminal justice system is the UK's our draft communications data bill. This bill is something that has been in the pipeline, if you like, for quite a few years now. We've gradually, since 2001, we've gradually put in place steps which progresses along a line towards retaining, collecting a lot more of our communications data, so the information, I'm sure all of you know this already, with the information around our communications, information about our web habits, who we're emailing and when, who we're calling, where from, for how long, and where it starts to get a bit more murky, things like weblogs, things like subscriber information about our social media accounts, who we like on Facebook, etc. And a couple of years back, our previous government tried to introduce a package which would require communications companies to collect information in a blanket way, communications data about all of our, in the UK, all of our web habits, and that includes information from overseas service providers. Even if the service providers overseas aren't willing to give it, that information will be taken effectively via arrangements with UK-based providers. When those plans were first introduced, or an attempt was made to introduce them a couple of years back, they were roundly sort of rejected. There was public opposition, opposition from the industry, opposition from civil society. They were eventually dropped. Now, unfortunately, we've seen them revived by this current government. And a bill was produced last summer. It's been subject to parliamentary scrutiny in the UK, and a very damning report was produced at the end of the year about the privacy implications of such a huge and blanket policy. And just to give you a flavour of how broad, how blanket this piece of legislation is, the first clause essentially allows the Secretary of State, by executive order, to require any communications company to do anything in relation, not just any communications company, any communications operator, so anybody in control of a communications device, to do anything in relation to that device in order to facilitate access to data at a later point by a public authority. So incredibly broad. Subversion, as we've heard, of ordinary law enforcement principles, the presumption of innocence, the blanket collection of information completely decoupled from suspicion of criminal activity. We're also seeing a shift in the relationship between the state, communications companies and the public. Never before in the UK have communications companies been called upon to actually act as an effective arm of our law enforcement agencies and collect information that they have no business case to collect, whilst at the moment they retain information which they keep for business purposes. There's never before been a requirement to actually actively go out there and do the job of the law enforcement agencies. Other real breaks with traditional kind of intelligence-led policing and law enforcement principles. The idea that many public authorities will have access to this. It's not just the police, it's not just the security services, it's public authorities, it's quangos, it's the egg inspectorates, it's local councils potentially. And aside from those local authorities, all of those organisations will have access via a process of internal organisation, so there's no process of warrantry of prior judicial authorisation. Again, our concerns here span the collection itself, arrangements for access which are incredibly lax, and arrangements for oversight of the system, which are also very, very weak retrospective oversight via sampling. So really not enough to make sure that this kind of incredible databases of information aren't abused and are kept safe. our government has made a number of claims about this scheme which absolutely do not stand up to scrutiny in our view, and they're arguments we've heard repeated again and again by our Home Secretary, by senior figures in our government. This idea, first of all, that communications data is not particularly revealing, well, I think if you think about really what we're dealing with here, if you think about weblogs, the fact that we can find out what newspaper you read, what political party you support from an analysis of your web history, find out who you're emailing and when, find out who you're calling and where you're making calls from with smartphones. This can lead to an incredibly full and incredibly complete and intimate picture of an individual's life. Again, we question the conceptual distinction between communications data and content, particularly when it comes to things like weblogs. How is the fact that you visited a medical website, which could be incredibly revealing, how can we really distinguish that from content in any meaningful way? The law enforcement gains, we're talking about a balance here, and we always have to be talking about a balance when we're talking about privacy-intrusive measures, and that we have so many unanswered questions in terms of the law enforcement gains that we expect, or that the government are predicting from this measure. We hear that communications data is used in lots of investigations. We've not been given proper information about the types of investigations it's used in, the extent of access and the numbers of individuals affected, the extent of the role of communications data in investigations, how many prosecutions are secured from the investigations which involve communications data, what role did communications data play in securing the prosecution, could other evidence have been used, how often is data which is already available the crucial data. Okay, I'm going to wrap it up now, but needless to say, many unanswered questions, and again, we say this is not about maintaining capability, this is massively extending the reach, given how much of our lives we live online, and from Liberty's perspective, the arrangements we currently have in place for data retention leave a lot to be desired, but this new regime really goes nowhere near to striking the kind of appropriate balance that we need. It's completely disproportionate and probably a breach of Article 8 in our view, and we'll certainly be looking to pursue cases if and when we get these kinds of arrangements in the UK.
Thank you, Mr. Chair, ladies and gentlemen. Hello to you all. As you all know, and I start from a very, very classic point of view, the objective of criminal justice, and I think it's important to underline it, is ex post punishment for committed guilty criminal behavior, and that in conformity with standards of rule of law, due process, human rights, and so on and so on. That means we have a sword function in criminal justice, and we have a shield function, combating crime and due process. The presumption of innocence is, of course, a long-standing principle at the very heart of the criminal justice system and enshrined in human rights conventions. And if I look at the provision in the European Convention of Human Rights, Article 6, paragraph 2, and I quote, "Everyone charged with a criminal offense shall be presumed innocent until proved guilty according to law." This might be, from the point of view of our topic, a very misleading formulation, because charged. It could be, of course, read as the indictment, and so the presumption of innocence is mostly playing at the trial phase. I will deal with the pre-trial phase. And charged, of course, here does not mean indictment. It does mean the moment from which a person on is a suspect. Formally be declared a suspect, or that he can derive from some acts of judicial authorities or police authorities that he is suspect, that he is a suspect. What does this mean? That when we are dealing with the pre-trial setting and the use of investigative powers and the use of surveillance as an investigative tool of criminal procedure, we have to define this. If I look, I've been looking around for some definitions. I found one, which is a classic one, in a document of the European Committee on Crime Problems of the Council of Europe. They say electronic monitoring as a form of surveillance is a form of surveillance with which to monitor the location, movement, and specific behavior of persons in the framework of the criminal justice process. That's a very classic definition. And even there we have problems. It includes electronic monitoring. In my eyes, it has to include the use of all telecommunication tools. Do we go so far to include remote control of computers? So remote surveillance, transnational global surveillance, some will call it remote computer search, which is of course not the same as surveillance, so we have already problems there. When I see this field of criminal investigation and the use of surveillance as a criminal investigation tool, and I go to the presumption of innocence, and I try to analyze this from a strict legal point of view. So I look, for instance, at the case law under Article 6 concerning that paragraph. I don't run very far. There are many, many problems with the surveillance techniques. They're mostly under 8, my colleague will speak about that, and they are, of course, also under 6, but linked to fair trial notions. Mostly the use of secret surveillance and the impossibility of the suspect and his lawyer to have access to the file, or to have the right to disclosure, or the confrontation clause at the trial. But this is, of course, it's another area than the presumption of innocence. Of course, there are problems when the gathered information by surveillance is used for naming and shaming in the pretrial setting. Then, of course, we run into real problems with the presumption of innocence. What I will do is explain you why the presumption of innocence is mostly out of the game, is set aside. And I will try, in a very brief setting, to try to focus on 4 points, which are shifts in the criminal justice system, and explaining why this principle is, at least also some other principles of the fair trial, out of the game. First, due to the security paradigm, we see a function creep, we see a net widening of the use of the criminal justice system. I said at the beginning, reactive use, we go more and more to proactive use, anticipative use of criminal investigation tools. So we are in criminal procedure, including surveillance. So that means that surveillance is used as a judicial tool by judicial authorities before the commission of a crime, before even the perpetration of the preparation of a crime. So the goal is to prevent crime. But if we are in certain anticipative setting, we need another definition, because it's not crime, it's risk or threat. And that's a complete other definition than the classic one of the Council of Europe. That means also we are not in a setting of criminal charge. We are not under Article 6.2. We do not have a suspect. We have maybe a dangerous person or a dangerous behavior, but we don't have a crime. So we don't have a suspect, we don't have suspicion, and of course if we don't have suspect and suspicion, we don't have presumption of innocence. So we're out of the game. Second, this conference of course is the illustration of it. So we are living in the information and digital society. When it comes to investigation, judicial investigation in the criminal justice system, today I would say the building up of an information position is as important as the use of classic investigative measures. And the building up of information positions for the police, for the judicial authorities, for administrative agencies which are in the pre-field, of course by storages and processing of information, in the public field, in the private field as a long arm of the public field, in a systematic way, giving access to enormous lots of information for, just an example, for profiling, is of course a complete new field of work for the judicial authorities. I'm underlining the judicial authorities. Third, when it comes to the players of the criminal justice system, traditionally we all have learned, at least at the old continent, these are the judicial authorities. They have been authorized by the state to use coercive powers. Within these judicial authorities, we see in many, many states a shift from judges to prosecutors. Pre-trial judges, examining judges, to prosecutors, and in some countries even very much from prosecutors to police authorities or enforcement authorities in the administrative field. This shift, of course, has something to do also with the lowering of the shield function, and come back to that. It's a shift from the judiciary to the executive bodies in the law enforcement field. Second, not in all countries, but in quite a lot of countries, we see that the intelligence community is coming in. And then I do not speak only about intelligence-led policing, let's say intelligence at the police forces or at the judicial authorities itself. I'm speaking about the security forces, the MI5, MI6 types. Their statutes have been changed. They got more and more coercive powers, which are parallel to the coercive powers under the criminal procedure. So there's a parallel set of powers, but still they have other functions, you could say. That's true, but we see in more and more countries that the intelligence they gather through the use of coercive powers, including, of course, secret surveillance, can be used as information or evidence in the criminal procedure. That means it can be used as the starting information to open a judicial investigation. It can be used as a sufficient threshold for coercive measures under criminal procedure. And in some countries, it can be used as direct evidence in criminal courts. Last, under the players, it has been mentioned many times in this conference, the privatization of the enforcement. So many private players, service providers, SWIFTs alike, PNR alike, and so on, come into play and do play a function, do have a function also in this public enforcement field. The last shift I want to mention is about the tools. First, of course, this information exchange under the criminal justice system has become very important between all these players. And we see in many countries that they are building what is called fusion centers, expert centers, with different players in order to be able to exchange all this information. Second, we see the increased use for what they call serious crime of special investigation techniques. So mostly secret surveillance and covert surveillance is, of course, a very important one. And what is important, the more serious the crime is, and the more serious the risk or the threat is, the more the threshold, so the procedural safeguards, are lowered. So you would expect the more coercive, the more coactive the measure, the higher the thresholds and the higher the procedural safeguards. It's just the opposite. Because the security paradigm is, of course, rebalancing the procedural safeguards, and they are lowered. Of course, last element, and with that I conclude. If we include, at least in the states where intelligence from intelligence services is included as evidence in criminal procedure, we have to deal with increasing secrecy in the criminal procedure. Secrecy at the stage of at the pre-trial stage, that means that the suspect has, of course, great difficulty to have access even to the gift, so the essence of that information, but also at the trial procedure. So we are confronted more and more with ex parte proceedings, so excluding to a certain extent the role of the suspect and his defense lawyer. That's the points I want to make to illustrate how this presumption of innocence has been set aside, and also some other fair trial principles by substantial shifts in the criminal justice system under the security paradigm. Thank you so much.
Good assumption of time.
Thank you. You're coming over?
I will try the remote because I'm not really... Just give it a try.
Okay. You want to make a standing act?
I will try this.
Try this.
The wireless one.
Yeah.
Is it working?
No, not yet.
Otherwise I can...
But you can use this one.
We have one here as well. Okay. Good afternoon, everyone. I'm Didier Wallaert from DLA Piper, working in the IT department and focusing on, among others, but in particular, data protection law and privacy law. We have been talking about surveillance. We have seen what is possible from a technical point of view. But as Rachel already touched upon, we need to be aware that surveillance... Oh, okay. Sorry. Yes, indeed. I will put these away then. They won't be on the DVD. Indeed. So as I was saying, and as you know, most of you know, surveillance is strictly regulated in Europe, and I will briefly talk about that European legal framework with some concrete examples. First of all, I will make a distinction between private and public surveillance. They're a bit overlapping, but just to show you that not always the same rules will apply. I will then give a short example on biometrics, and last I will show that there is, as you know, some state surveillance from one state to another, and that is not always in line with privacy laws. First of all, private surveillance. I have mentioned some examples there. You may know RFID chips that are in your luggage to make sure that the right luggage is on the right plane. We have CCTV already mentioned by Rachel. Biometrics, facial recognition, as already explained by Ulrich. So all these types of surveillance techniques were first of all used in the public sector, but now they are more and more commonly used in the private sector because they're more and more affordable. So private companies are using them. We, for instance, have a client that is using now fingerprints instead of badges to enter a building, with all consequences, legal consequences. The most important regulation, as you know, is the Privacy Directive, which is currently under review by the European Commission, the European Parliament, but it's still valid, of course. And the most important, I listed there, the most important principles that will apply, and that we have to check each time you're using or implementing an example of surveillance. So first of all, we need a legal ground. That legal ground can be the consent of the data subject, the person that is actually under surveillance. Most companies, private companies, are trying to use the legitimate interest, but as most of you know, the legitimate interest has to be checked against the human rights of the data subject itself. So it should be sure that that legitimate interest will not overrule the human rights, among others, the privacy laws of that data subject. And that's also under discussion now in the new draft data protection regulation, and in particular the views of the European Parliament there. We have transparency, so one should be informed about the use of those techniques. There must be sufficient security measures in place, for instance, to avoid that surveillance data will not be shared with third parties. Should be notified to, in most countries, there is a need for a notification to the data protection authorities. That's not always the case in the UK, I know, but in most other countries that's the case. We have to make sure that data are not transferred to non-EEA countries, jurisdictions, and if that's the case, we must use, for instance, safe harbor when there's a transfer to the US, or model clauses. So these are all principles that must be taken into account when we will actually implement, when a private organization is implementing surveillance techniques. So it's not that easy just to put it in place. We have to take care of this, and all this is, of course, subject to criminal sanctions in most of the European member states. Then, the public surveillance, that's a bit of another story. So again, we have the examples already given. Another one is, for instance, GPS surveillance that is also used by public prosecutors. So CCTV on highways, it must not always be a surveillance in a public prosecution context. It can also be, for instance, monitoring of traffic, etc., etc. But we have to be aware that the privacy directive, the protection directive, is not always applying on public surveillance, and in particular on public prosecution surveillance. There is an exception in the directive. Is actually saying that for public security, defense, state security, etc., those rules are not applying. However, we are not without any regulation there. There's still the Article 8, as John already mentioned, Article 8 of the European Convention on Human Rights, and the actions carried out by the states, even when that's foreseen in their actual legislation, will still be checked under Article 8. There is some case law of the European Court of Human Rights there, for instance, on GPS tracking, that is actually using the exception, because we have Article 8, of course, which is again showing the principle that there's a need for privacy protection, but again, we have the exception, luckily, for national security, public safety, etc., etc. And an example here is in Germany, I guess, there was a bomber or a terrorist that was convicted, and he was invoking that his privacy was, because there was a GPS tracking device used on his car, that his privacy rights were violated. But there the European Court of Human Rights stated that the states in Germany could actually use this technique. So it was okay under Article 8. A quick example on biometrics. So biometrics, you may all know what biometric surveillance is. We already had facial recognition, vocal recognition, iris scan, vein pattern is used as well. Again, here we have to check whether this is in line with the European Privacy Directive, and there is interpreting that directive and the rules in that directive, specifically on biometrics surveillance. There is an important document, an opinion of the European Working Party, Article 29, that is actually explaining the principles that we just touched upon in a bit more detail. But I won't go into the details just to not to run out of time. But it's an important document if you're ever coming across with issues in relation to biometrics. Go and see that Working Party document 193. A very important issue that, an important topic that has been discussed all over the conference already is privacy by design, and that's, in particular with biometrics, a very important principle that must be applied. So you all know what privacy by design is. That's important for firms such as Ulrich's firm, that and other private and also public, but most in particular private organizations, that the product you're offering is actually already in compliance with privacy laws. And as regards surveillance, some legal scholars have added there a new principle, surveillance impact assessments. And you have the privacy impact assessments and the surveillance impact assessments that are linked to privacy by design. And those surveillance impact assessments are actually meant not only to assess what is possible under privacy laws, but also what is moral and what is possible under other human rights, as for instance Article 6. So these should all be taken into account when we are assessing and trying to implement surveillance techniques. And then, as I already announced, a quick word about the cross-border surveillance. So surveillance is not only something that happens in our backyards. We have the famous US Patriot Act. That's just an example, because there are many other countries and many other jurisdictions that are monitoring data subjects in the EU. But that's linked, and that's why I use this to cloud computing. For instance, when there is a European company active in the EU that is using a product, a cloud computing product from a company in the US, even if that company is just doing some minor business in the US, it may be subject to the US Patriot Act. It may be possible that that authorities in the United States may request data from that European client of the cloud provider, and that data must be sent to the US. And that is not always in line with, as I already told, with European data protection legislation, as transfer to the US cannot, in principle, not take place as such. It's not that black and white as I am telling it here. It's a bit. Oh, I'm over time because I'm rounding it up. I'm talking about the US, so it's and final word is just that this is the knife is actually cutting on both sides, because we had the same issue in Belgium, that actually Belgian public prosecutor was asking access to Yahoo data. So Yahoo is, as you know, a US company of Yahoo customers in Belgium. It's quite a complex story, but I would then recommend that we can perhaps discuss on it later on, or please happy to answer any questions. That was it for me.
Great, thank you. Is this live, whatever part of it? You know you're all being videoed, and you probably don't. How many people remember agreeing to the, I thought it was being, you know, anyway, it's one of those things, the 40%. Rich set of presentations, thoughtful, fair, balanced, and suggesting the diversity across cultures, places. I want to just make two quick comments. A moderator is supposed to moderate, but a moderator can also be a provocateur. And should the panelists choose to respond to these issues, I would welcome them. First, you know, this is not only about, this is about norms, I think, not simply about legality. And if we look at norms and rules, particularly those regarding eligibility, but also perhaps a bit in the criminal law, I wonder if we could suggest that surveillance, rather than necessarily violating the presumption of innocence, that surveillance could be viewed as the tool to validate and to create innocence, whether that is through deterrence or through careful checking of eligibility. A second point, and there's a sense here, the conflict elements of this have perhaps not been brought out as clearly as they might. And underlying an awful lot of this is the old division, I think the Latin concern with who guards the guards. So I would ask the question, if these techniques are as good and reliable and powerful and effective and efficient and all the other nice things that our colleagues in industry associations and in law enforcement would suggest, and if there are real threats to abuse, given the secrecy and the power of the tools, as they also are well aware, what are the consequences of institutionalizing the wonderful principle of reciprocity and some kind of equity? What would we think of using surveillance as a tool to control those who would use surveillance to abuse and to violate others? Should police officers have implanted in them some kind excuse me, of a chip? Should all interactions between the police and the public be audio and video taped, and etc.? Anyway, do any of the presenters care to respond to anything they heard from other presenters? Oh, come on, you couldn't have agreed with everything. Let's get real and be honest here. Well, but let me let the panel respond to anything first, and then we'll go to the audience. But it's okay to be diplomatic and polite and European rather than crass and direct and American cowboys. But, no? Okay, please.
Thank you. Martin Hoskins. Can I just thank Rachel for her not so kind comments about the draft communications data bill, but can I assure her that in about 4 weeks' time, a new communications data bill is going to be laid before Parliament, and there are going to be riots. But the riots aren't going to be in London. They're going to be in Paris, and they're going to be in Brussels, and they're going to be in Berlin, because everyone is going to be so jealous about what the Brits have been able to get away with. They will see how the Brits can be so democratic about this form of communications surveillance. You all might be saying, I want this as well. You might be saying, I want to have the sorts of choices that the British Parliament is going to be given fairly soon on this subject. Can I suggest to you that the Brits may not be very good at being Europeans, but they're going to be very, very good when it comes to the democratisation of communication surveillance.
Yes, I mean, we're not expecting these proposals to be abandoned. We know that the Home Office is going to come back, and they're going to come back with something which is more palatable but still leaves a great deal to be desired. There has been a lot of politicking going on around this bill and around communications data, not just within this administration but for a very long time. But what we got with our draft communications data bill was a mind-bendingly broad bill which couldn't have been more future-proofed, more broadly defined. And what we're probably going to get now is something which pinpoints more precisely the kinds of communications data the Home Office are interested in capturing now. That's not enough for them, because they want to be able to adapt when new technologies are developed and do what they feel is appropriate without having to go through the boring process of legislation and democratic involvement in the process at some later points. But we, as a government watchdog, as an organisation very much involved in the political process in the UK, are confident at this stage that there is a huge opposition both within and outside Parliament to this bill. Opposition not just from sort of Her Majesty's opposition, but opposition, strong opposition from within the two parties in government, and a great deal of public outcry at these proposals. And so we very much hope that through democratic process, we will see these proposals defeated, and it's certainly, these proposals have been quashed once before in the UK, exactly the same essentially proposals, and we're confident that it can happen again.
Willem de Beukelaar, Belgium Commissioner. I'm a little bit surprised by the importance that is given to the presumption of innocence, because I think that it is one of the fundamental rights that must lead to a fair trial, to have a just and fair society and trial. And I'm fully share the analysis of Professor Vervaele when he see a shift coming on of the judiciary to the administrative point. And I think that is much more dangerous than maybe the erosion of this presumption, because, and I said it because we are here on a privacy, on a protection of data, and when we see the new proposal, the European proposal, then we see that there is a whole chapter, Article 79, who is describing, who is imposing administrative sanctions. So you see that the data protection authorities will have the obligation, not the possibility, the obligation, not only to install a sort of general surveillance on the threats on privacy, surveillance. They have to do investigations, they have to do audits, they have to prosecute, they can even oblige to prosecute, and they have also to take decisions on sanctions. They have to be also the judge. So I find it much more dangerous that the separation of powers, that it will be vanished in this proposal, and I think that it is much more difficult to accept that than discussing on the presumption of innocence, because if you have to make the investigation, if you have to do the prosecution, and then you have to make a fair trial on all these elements, I am a poor commissioner, but I don't have 3 or 4 faces.
It's hidden under my materials. Thank you, Willem, for your observation. I would like to make a caveat, though. I think in many states, not only in Europe, but also outside of Europe, we have also a long-standing tradition with administrative agencies that are regulatory agencies. They have supervisory powers, and they are sanctioning. We have them in many, many fields. Of course, when they are in the punitive field, and then we are certainly in the area of Article 6, be it 1 or 2, it doesn't matter. Not civil rights and obligations or criminal charge. They have to comply with the same basic principles and norms. That means that the presumption of innocence must be part of their processing when they are in supervision and sanctioning. So I would not say, that's my caveat, that as such, the fact that you establish DPAs as enforcement authorities, because that's the shift, of course, is as such a violation. It depends how it is organized. And of course, then you need separation between certain functions. There must be Chinese walls, and so on and so on. So there are many points, of course, of interest, but I would not say that as such it is a violation of. That's my caveat.
Other panelists wish to respond? Okay, how about yes? You please.
Without a mic. Yeah, but the material also then.
Let's get them.
We hear you, but maybe at the back benches. There's a blue spot.
That's the nice thing about a place like MIT or Technion, you know, this stuff works. Yeah. Culture of this soft business.
Thanks. My name is Matthias Vermeulen. I work at LSTS here in Brussels and also at the European University Institute in Florence. And I was really struck by one sentence that Mr. Wallaert was marking when he almost casually said, I think everybody knows what we mean with privacy by design. But I think that one of the problems of this whole concept of privacy by design is exactly that it means something completely different to almost everybody that you ask what is privacy by design. In a way, it is actually, well, that's my point of view, it's a bit the sustainable development of this era. It means everything and nothing at the same time. And that's why I would like to go to Mr. Seldeslachts and actually ask a very concrete question on how you have implemented privacy by design and how has it made a surveillance technology that you have been dealing with. You can choose whatever technology you want. And how has it made this technology more privacy-proof, so to speak, because that's how I understand them, privacy by design.
Basically, we have not implemented privacy by design. And by we, I mean the whole of the industry that I'm representing. At the same time, I would like to try to convey to you that this is also for us, and probably even more for us, a major challenge in understanding, number one, what is meant by, because in the end, my companies will have to implement it, but also towards the end users who will then have to implement it correctly. And as we can see already today from the security techniques, which are generally not implemented correctly in many occasions. So in terms of privacy by design, there will also be the question of, okay, let's say that some of the companies that we are involved in will be able to develop technologies based upon privacy by design or even default. And then there becomes, let's say, the difficult implementation, installation, who is going to be held responsible for this. So that's, I think, one of the major issues that's heading to our industry. At the same time, I would like to mention that quite a number of our companies have been making progress in doing developments in that area, and there have been techniques being developed, basically anonymization techniques, techniques for making sure that there is some privacy enhancements involved. To give you a couple of examples, there are a number of firewall vendors out there today that specifically to apply to European rules, and those are typically American firewall vendors. They have been implementing anonymization techniques specifically for the monitoring of those. So it's an ongoing process, and there's developments ongoing, but there's a lot of work that needs to be done, and so I think from the industry we'll ask for a bit of patience there.
Good. We have 3 more comments. So with the microphone there, please.
Yes, I have a comment for the last speaker, which make a distinction between surveillance by private actors and public actors. And I believe that distinction is not always very easy, and it's not very easy always to know which norms apply. I'll give you an example. I work in projects where railway and public transport companies want to use video surveillance for a specific purpose. Normally and traditionally, video surveillance is used to survey places. Now they want to use it to track people. So if they survey places, well, yeah, you are in the traditional 9546 case. But if you want to track people, you come under criminal law. Yes, if you want to track someone under our area, normally you should have in most European countries, please believe even all of them, you should have an authorization of a prosecutor. But then there is a nuance, because some companies says, well, no, we are not tracking people. We are surveying places by tracking people. We are tracking meter by meter, not kilometers by kilometers. So is that thing surveying a place, 9546, or tracking someone for which you need an authorization? You see,
good question.
That's
some answers. Thank you.
Well, my personal opinion would be that, first of all, the most strict rule would need to apply, and that exceptions should always be interpreted in a restricted manner, as it is done from a legal point of view. And so we first should see whether there is a processing here that is falling under the Data Protection Directive or one of the local laws, and whether the exception, so if there is here in case really something in sense of criminal prosecution, public security, if that would apply, but interpreted in a very restrictive manner, then yes, I agree, the rules would in principle not, the general rules on data privacy would not apply, but the first principle should always be that they apply. And I agree with you that it's a very gray zone, but that's an important test that must be made. And then I would refer again to Mr. De Beukelaar. It's perhaps good to give a quick call to the specialist of the Privacy Commission. Then
if you have a response from the other panelists, or we can move on to a question in the back here. There was a person here. No, I had somebody back here. Yeah, we had one over.
Hi, I have a question. I may be going out on a tangent a bit for you guys, but it's about surveillance of children, and particularly in schools. That one of the things that's happening in the UK is the kind of normalization of surveillance. And I noticed you mentioned things like biometrics used to access buildings. They're using biometrics to access school lunches in schools in England. You have to put a fingerprint in to get access to the lunch in the canteen. The question is really, has children's privacy in relation to surveillance been taken into account? Things like consent and things like the children's right to privacy, which is in there in the Convention on the Rights of the Child, but doesn't seem, as far as I can see, to be taken at all seriously by either law or practice. Do you have any comments about that?
Thank you. Yeah, really important point you raised there. When it comes to children and surveillance, this is one of the core critical areas we see in terms of the real impact of surveillance techniques. If children become acclimatized to being surveilled within their school environment, you know, that sends out a very worrying signal and creates a worrying image for the future, if you like. I do think that there is a degree of sensitivity to this. We have seen the coalition government in the Protection of Freedoms Act bring in new requirements in terms of the consent required before children's biometrics can be taken. But perhaps these measures don't go far enough, but at least we're seeing some kind of sensitivity to the potential impact. Before, we had a situation where children's fingerprints could be taken in schools without the consent of parents even. But yes, there is an ongoing question here. Another interesting issue is the extent to which CCTV should be used in schools. Very provocative, very sensitive issue. So yes, absolutely. If we're concerned about surveillance, then one of our top priorities has to be how it's used in relation to vulnerable young people.
Hi, Axel Armok, University of Amsterdam. I would be very interested to learn more about the surveillance reciprocity or symmetry, which already was proposed in '98, I think, by David Brin. What has our thinking about it advanced since then? Second point is there was a recent fire at Vodafone in the Netherlands. All the records of data retention and all the backups were destroyed. And the Justice Minister declared that there was no effect on law enforcement. So my question to Mr. Seldeslachts would be, how does that affect the sales pitches of the companies you represent back in 2005? That data retention was absolutely necessary. And on the information security perspective, do you also advise currently that the accumulation of troves of data is a cyber security or information security risk in itself?
Of course, I mean, collecting data retention in itself means that you're actually collecting data. And as we are talking about data security, of course there has to be security on those types of data as well, as is for surveillance type of activities all over the place. So yes, obviously there has to be some protection there in terms of reciprocity, and also what Gary suggested earlier on. Basically, I think we are in a process of seeing techniques and technologies where additional controls are being put forward and being suggested as well. Actually, I think 5 or 6 years ago, it was actually Oracle that started to make the suggestion towards the industry not to have a system administrator accessing all of the data, whilst in the 15 years before that, they were actually making sure that there was one single system administrator who would have access to all of the data sets. So basically, I think there is an example how this industry is evolving, and an understanding also that there is no single entity that can also control, and that there are different types of power that are somewhere in between. One final comment maybe on the suggestion of the cameras and how they are evolving. I think it's a very good monitoring that you did, but on all of the technologies that exist today, including surveillance cameras, if you have today an allowance to put a public space surveillance camera somewhere, and let's say a surveillance camera goes out of order, or whatever happens with it, and you put a new one in place with some very advanced types of potential and capabilities, then suddenly the aspect of ratio that you have for that specific frame suddenly appears to widen, or you suddenly are capable of also monitoring and identifying other types of activities in that environment. So I think there's also something to consider there towards the evolution of those things towards the future.
Great. Okay, I have none of the informal rules here, but the bell rang. That's only one kind of law. We can transcend it by not moving. So does anybody have one more passionate question they'd like to ask?
Mr. Seldeslachts, you said before that in terms of finding techniques, the industry is doing optimization and things of that kind. Do you publish the details of all sorts of protections, technical details, would they be available more widely, or is that under commercial confidentiality?
I know of some of the companies that we work with, they do publish the way that they use the types of anonymization processes they use, so the types of encryption technologies and the methodologies they apply, and they are being made public. In some cases, it's on a commercial in confidence base, so the time that you go into discussion and commercial negotiation, you will be able to discuss those more in detail and in depth. Are they available for public research? Probably, if you start asking them about it, it should be a possibility. Yes.
Okay, I'll presume this was a successful session, and I'll